Welcome back. My name is Thomas Lundmark, and this is my tutorial on the features of common law and civil law systems. Today we'll be discussing the use of statutes and judicial decisions. Specifically, we'll be seeing how judges justify their decisions. They'll make their decisions based on authorities, and we'll look at two kinds of authority, those based on statute and those authorities based on case decisions. For our examples today, we will be using the same hypothetical factual situation regarding a woman named Camilla who purchases a hamster from a man, David, who breeds and raises hamsters. A few days after bringing the hamster home, Camilla becomes seriously ill and has to be hospitalized for a disease. Expert testimony establishes that Camilla contracted the disease from the hamster. The legal question before us is, can Camilla recover damages, that is, compensation, from David? We'll be applying this product liability rule in the first examples. Let me read it for you. A manufacturer is liable strictly in tort when an article he places on the market proves to have a defect that causes injury to a human being. We'll be looking at four approaches, or what you might think of as arguments, to the application of rules. And we'll see that these arguments are used for both statute rules and case-based rules. The four basic approaches are the textual approach, the historical approach, the functional approach, and the analogical approach. Let's begin with the textual approach. It asks, what did they say? That is, what does the rule say? We'll look at the legal terms. And in the product liability rule, we'll concentrate first on what does manufacturer mean and what does article mean. For purposes of this tutorial, I looked up the word manufacturer in the Oxford Online Dictionary and found the definition: manufacturer means a person or company that makes goods for sale. David is a person, but does he make goods for sale? Now, hamsters might be goods because they are merchandise or possessions, but is David making hamsters? In the same dictionary, the word make is defined to mean to form something by putting parts together or combining substances. Create. I think most of us would agree that David is not creating something when he's breeding hamsters. So if we're limited to the textual approach, we'd almost be compelled, maybe someone could fashion an argument, but let's just say we'd be compelled to rule against Camilla. Now, if we thought Camilla should win, we might look for historical evidence that would support a construction in her favor. That would be an example of the historical approach. For example, if we found a statement in a committee report that said, we intend that the word manufacturer should include breeders of animals. Now, under the historical approach, we ask, what did they mean, or what would they do if confronted by this legal question? And if we have such evidence, we could pretend to ourselves that we're talking with members of the legislature, and then we would think, if we had this sentence that manufacturers should include breeders of animals, that they would likely agree with us if we wanted to give Camilla a right to recover against David. Now notice that we could make the same argument if this sentence, we intend that the word manufacturer should include breeders of animals, were found in a case decision. It's the same intellectual exercise. We ask ourselves, what would the judges who announced this rule decide today if faced with our legal question? And we would be pretty confident in saying that those judges would likely rule that David is a manufacturer for purposes of the product liability rule. Let's move on to the functional approach. That asks, what do you as judges think the rule should mean? But you're limited in what you think the rule should mean, not to the text or to the history, but to the functions or purposes behind the text. Now for product liability, strict liability for products, most people define two policies behind the rule. The first is to spread the risks of unsafe products to all the consumers of the product, so that not only Camillus should pay for the injuries, but the other users or buyers of hamsters from David should also pay. The other argument is to create a financial incentive to make products safer by internalizing the cost, we say. The argument there is that if David has to pay, then he'll be extra careful, as will others, when they're breeding their animals to make sure that they do not carry any diseases. Using the functional approach, I think we'd be able to support awarding Camilla damages against David. Now for the analogical approach, I'd like to use the same hypothetical factual situation, but I'd like to use another rule. I'm referring to it as the Unwholesome Food Ordinance, or UFO. It reads as follows: "It is illegal to sell any food that is diseased, unwholesome, or injurious to health. Anyone who violates this ordinance is liable for the injury caused." Could we apply this rule to our factual situation? Is a hamster food that is diseased? Well, it is diseased, but it's not food. Could we somehow stretch this out, right, in a purposive or functional way to say this should apply to things that are not food? My reaction would be to say no, but we could apply this rule by analogy. Analogy works like this, that the UFO is designed to protect consumers from diseased food, and we can apply it to a situation so as to protect consumers from diseased animals that they buy. That would be an application of the analogical approach. I said at the outset that judges use rules from cases in the same way that they use rules from statutes, that is, as authorities to justify their decisions. Now the reason that they use rules the same way, regardless of their source, is that case-based rules are indistinguishable from statutory rules. We already saw one example of this. Number 4, a manufacturer is strictly liable in tort when an article he places on the market proves to have a defect that causes injury to a human being. In fact, that rule is taken from case law in California. But inside the European Union, it is practically the same rule, but found in a directive, the European Product Liability Directive. In other words, the rule can be created by judges or by some legislative entity. Or let's take an example as the first rule. No one shall take advantage of his own wrong, a very broad rule. That was created by judges in England, but it has been adopted as a statute in the Civil Code in California. You cannot tell by reading the rule whether judges announced the rule or whether legislators, members of parliament, announced the rule. By saying that rules from cases are indistinguishable from statute rules, I do not mean to say that the judges will use the same approaches just as often when they have case rules as when they have statute rules. That is not the case. In fact, there's quite a bit of variation inside one jurisdiction on that point. And by the way, there's even more variation when one compares courts in common law countries to courts in the civilian tradition. If you're interested in following up on this topic, I suggest that you read carefully my script for this lecture, and also that you consult Chapter 7 of my book, Charting the Divide Between Common and Civil Law. Thank you very much.